Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? AI technology has introduced new complexities, both into the workplace and the workforce, as well as novel and sometimes conflicting regulatory developments. On this episode of We Get AI for Work, we speak with our special guest, Brittany Sakata, General Counsel for the American Staffing Association, who joins us to discuss the expanding effect of these regulations and the latest guidance, as well as some of the most pressing concerns facing the staffing and recruiting industries. Brittany advises ASA members on a broad range of legal matters. She is Principal ASA Liaison to the formal ASA OSHA Temporary Worker Safety Alliance, Office of Disability Employment Policy Alliance, and the ASA Employee Safety Committee. Today's co-hosts are Eric Felsberg, Principal in Jackson Lewis's Long Island office, and Joe Lazzarati, Principal in the firm's Tampa office, and co-leaders of the firm's AI group. Eric, Joe, and Brittany, the question on everyone's mind today is: who is using AI? Where is AI being regulated? And what should businesses do to comply? And how does that impact my organization?
Thank you, Alicia, and hello, everyone, and welcome to our latest episode of We Get AI for Work. My name is Eric Felsberg, and I'm here with my colleague, Joe Lazzarati.
Thanks, Eric. Definitely looking forward to it.
So, Joe, this should be a fun episode, right? We have the pleasure of speaking with Brittany Sakata, GC at the American Staffing Association. Welcome, Brittany. How are you?
Hi, Eric, Joe. Great to be here. Thanks for having me.
Excellent, excellent. Well, we're thrilled to have you with us. And, I know we've met before the podcast today, and, I know we have a bunch of stuff we want to talk about. So I think before we get into the substance, maybe the best place to start is to have you tell us a little bit about your organization, your members, what you do at the association, and the role AI plays in your organization.
Yeah, thrilled to talk about all of those things. ASA is the voice of the U.S. staffing, recruiting, and workforce solution industry. We advance the interests of the staffing industry across all sectors through advocacy, research, education. We have around 1,500 members, and they place, source, find workers for every industry in the U.S., from C-level executive, industrial workers, IT, healthcare, you name it. Our members are finding workers in those spaces. The ASA legal team, we work really hard to keep our members up to date on changes in laws, regulations, and we advocate for the industry. And so every year we track hundreds of federal and state bills, court decisions, agency rulings, and provide our members with really that comprehensive legal information and guidance, and also resources to really help manage and protect their businesses. And AI has introduced yet another wrinkle into the world of employment and HR. And it's a unique issue that seems to touch on all of our members, regardless of size and sophistication and the industry in which they place. So thrilled to be here today to talk to you about it.
Yeah, absolutely. So as we're getting ready for our discussion today, we were talking about the regulatory landscape and how it just seems to be developing almost on a daily basis. There's guidance, there's regulations, and, on the federal and state and local levels, both of us, Eric and I, sit not too far outside of New York City. So, we're both working on issues under the New York City AEDT law. So thinking about all of those developments across the U.S., potentially affecting AI, what are some of the most pressing concerns that you have as you see this legislation emerge?
Yeah, you hit the nail on the head when you said it's rapidly developing and it's coming from all directions. We monitor, as I said, at both the state and federal level. The federal bills we've seen have been pretty broad, and they touch on things as broad as, child pornography all the way to privacy. deep fakes, really just a variety of pieces, not so much on the employment aspect. So we've been taking more of a wait and see approach with those bills. On the state level, though, it's wild. You mentioned the New York bill, which of course was the first of its kind. We were heavily involved in both the lobbying aspect of it and then at the regulation stage, trying to get language that would permit our employers to comply in a way that was within the spirit of the law, but also recognize the business challenges that employers face of all sizes and navigating the requirements of that New York bill. And then since then, it seems like the states are just trying to compete to see who can be the first to roll out the next thing. And we saw it with Colorado. California, till the very last minute, had a very robust AI bill that would have impacted all employers that do business in California. So it's a hotbed of topics and issues within the legislation that we're engaging on as well. As it relates to employers, staffing firms are uniquely impacted by these laws because what they seek to do is impose a lot of record keeping, audit requirements, impact assessments, data sharing with candidates. And staffing firms are in the business of hiring people. And so their databases of candidates can be tens of thousands deep. And so when they run a keyword search to figure out, what are the top 10 candidates for a particular job opening that needs to be filled by tomorrow, the obligation to perhaps put out notices, give opt-out rights, which is something we saw in some states, that creates a huge headache and a compliance quagmire for our members. And so when we're engaging at the state level, it's really around educating legislators around our business model, the work that we do, the turnaround time that's needed, and how AI is a tool that can be used when effective in a way that really supports the job growth in the local economy. And so it's a challenging environment because legislators, on the other hand, also don't, I think, a lot of times truly understand, frankly, what AI is. And if they do understand it, they struggle to grasp sort of how broad the language in the bills that they're putting together, how far it goes.
Yeah, and look, I think that's always a challenge, right? I was kind of grinning as you were saying that. I think a lot of times these regulators are in a difficult position, and legislators, as you mentioned, because they know this is out there. They know, at least in some respect, it needs to be addressed. But AI is complicated, right? And kind of how does this work? And, without knowing exactly how it operates, how are you to then regulate it? So I do think about that a lot, but just sticking with that, the legislation, is we understand that you're not seeing the partisan divide, right, in the area of AI that you typically see with other legislative proposals and regulatory activity in your industry. So can you elaborate a little bit on that and, kind of what you see as the implication for that in your business?
Yeah, I mean, so we have, like I said, members that place in all industries all across the US. And employment laws typically, as it relates to staffing, fall into buckets of either, laws that are directly aimed at the industry, thankfully, which are pretty few and far between, and then laws that just have unique impacts on the industry. And the states where we tend to see more employment related laws that have a unique impact on staffing and those that just impact staffing as employers generally typically fall in your more blue states, right? California, New York, New Jersey, Massachusetts, Illinois. Those are where I used to spend the majority of my time. Now I'm engaged through the US Chamber. We're part of their working group with employers in conversations with legislators in Texas, right? As other states get in on this and they're trying to figure out how to take sort of, let's say, a conservative leaning approach, a more business friendly approach. And they don't know how to do it because, again, these issues are new, they're challenging. You want to make sure that you're protecting consumers, but you also want to take an approach that businesses can comply with, regardless of their level of sophistication and size. And so what we're seeing suddenly, and I think 2025 is going to be really interesting, is we're not seeing the typical states where we're engaged, and we're going to start picking up lobbyists in new areas in an effort to make sure that our voices are heard in states where we frankly typically haven't had to have a big presence.
That's really interesting. And maybe switching gears for a moment, one of the questions that I know I have in my mind, I think a lot of lawyers and practitioners and others, maybe even regulators, have on their mind, and that is allocation of liability. So I think this is really a pretty significant concern for employers for a lot of reasons. But in the staffing industry, we think it may be a little bit more complicated because of some of the nuances and the parties that are at play. Because you have, maybe the third party that's supplying the AI, you have the staffing company that's supplying the labor, and you have, the employer who is the one making the employment decision. And so you kind of have to say, well, do we vet the AI tool? Does the supplied labor fit the metrics that we were hoping to get from those candidates? And in making that selection. And so a lot of the times the AI tool is being developed and deployed by this third party. But on the other hand, you have the end user, which is the employer, and they're the ones receiving the labor. So again, there's kind of these moving parts when you think about the transaction involving staffing companies, and then at the same time considering, okay, how do you allocate the liability among those parties, especially if there's some kind of bias or discrimination. I know we talked about the AETT law in New York City, and that being a prime example, because bias is really the main point under that regulation, under that rule. So, given that there's this bias concern with all those moving parts, can you kind of talk to us a little bit about who holds that liability? And maybe it's not just one of those parties, maybe it's some or all of them, but we'd love to hear your thoughts on that, particularly in your industry and your position.
Yeah. Yeah, you said it. We at ASA spend a lot of time telling our members, the clients that utilize our members, regulators, lawmakers, that joint employment or co-employment is not a bad thing. It's just a thing, right? And when you have a staffing relationship, you inherently have two employers. And depending on the laws involved, there's very likely co-employment risk and liability potentially involved. As it relates to OSHA, right? You don't get to expose a temporary worker to job hazards just because they're a temporary worker, right? You still have to ensure that temporary workers are entitled to all the same safety and health protections that are an internal worker. You can't sexually harass a temporary worker just because they're a temporary worker. The EEO laws out there exist to protect workers regardless of who the supervising employer is. And so as we think about liability as it relates to employment decisions and the use of AI, I think there are going to be some cases and some decisions that come out in the next few years that say, hey, this party actually had a bit of decision making involved here and they had some skin in the game. And so the EEO laws as written, and again, they were written pre-AI technology, right? There's going to potentially be some liability found. We've seen it in California as it relates to a job board. There was an agency argument put forth by the EEOC out there saying that the job board couldn't hide behind the claim that they weren't an employer. Rather, they were an agent. And so there should be some liability. That's still pending. That's a novel legal issue. And so I think clients and staffing firms alike are right to be cognizant of this gray area that you've just identified. What does your contract language say about it? What are the expectations around your staffing firm provider? And what due diligence are you expecting your staffing firm provider to do as part of their onboarding and recruiting process for your positions open at your business? Those are good conversations to be having. And they can't be had once. They need to be had regularly because the technology is evolving. So I think liability in the AI context is incredibly unknown at this point. But I suspect within the next couple of years, we'll see some really interesting case law that will put your clients, my members, on notice and probably have some best practices around contracting and compliance conversations.
Yeah, I think it's a fascinating area because, and you touched on this, right? You have a lot of rapidly developing laws out there, but there's a whole body of law that was written when AI wasn't a thing, right? Maybe it was being developed and, us who were not in the know on that type of thing, maybe it was being developed, but certainly back in the 70s when some of these laws were kind of written, nobody was thinking about AI. So it's interesting, and it is going to be interesting to see how this develops. And I think I agree with you. Over the next several years, it almost seems like a foregone conclusion that we will have, some sort of at least body of case law start to develop around this issue. So again, there's something else for employers to think about in the AI space. So Brittany, this has been an excellent discussion, very thought-provoking. So as Joe and I like to do, we like to put our guests on the hot seat just for a minute here and ask you to kind of leave us with your top 3 takeaways as they apply to the use of AI in your business.
Yeah, I had a hard time coming up with just 3 because I think it is such a unique area that's rapidly developing. So perhaps we get together in 6 months and see if the top 3 have changed, Eric. But I would say as a starting point, your clients, members of mine, non-ASA members, they should be understanding what AI is being utilized currently. There should be an AI audit of what's being used currently in their business, use cases developed. Recently at ASI, I underwent that analysis on behalf of the association with our staff. And I was frankly very surprised by not just the number of ASA employees using AI, but the variety and what they were using it for. And I had the very distinct impression that if I asked the question again 3 months from now, it would be a much different response. It's just such a rapidly developing area. AI is not evil. It just is. And so understanding why it's being used, how it's being used, what are the policies and procedures in place to address those uses? What are the contract terms of the products that are being used? The lawyer and me those are the things that I think about. 2, I would say, as you're assessing vendors, a number of the proposed state laws have disclosure requirements, information that would be required by the vendors, the developers of AI, that would need to be shared with employers to allow them to assess whether the AI, could survive an audit or an impact assessment from a discrimination standpoint. Are you having those conversations? Are you understanding what you're entitled to from a state law perspective? Are you getting that information? Some states are requiring, at least in draft bills, annual reviews. What are the expectations of that vendor? Will they be providing that to you? Do you have to go out and ask for it? I think understanding and calendaring those obligations will help you stay on top of this really rapidly changing area. And then finally, stay connected with some organization that'll help keep you up to date on these issues and the development of these laws. Become an ASA member, join your state or federal U.S. chamber, sign up for Eric's privacy newsletter. Being on top of these things will allow you to play offense and not defense. And I think that's really critical right now when things are coming at employers so fast.
Thanks again, Brittany. So we were excited for this discussion, and for obvious reasons, we had good reason to be excited. That was terrific content, great discussion. For all of our listeners, we hope you found this discussion helpful. If you have any questions or would like us to cover a certain AI-related topic, please do not hesitate to contact us at ai@jacksonlewis.com. And until next time, thanks for listening.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.